Hello, good evening. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments. It can be anything that's immigration related. Now, I am U.S. Immigration Attorney Sharifa Tharpe, and I assist clients to get their status in the United States. And I come on here every day. I come on here live around 4 p.m. Eastern time to be able to answer your questions and bring good topics for you. Today, I have a very good topic, and it's what if the USCIS wants to deny your application? So let's start with this. Today, I got very good news. A client came to me and they came to me with a difficult case. They got what's called a notice of intent to deny from the USCIS. Now that notice of intent to deny does not mean they have denied your case, but what it does mean is that they intend to deny it unless you can provide them evidence to decide otherwise. So this was one of those tough cases. It was marriage-based, and the USCIS, based on the evidence provided, did not believe that the client's marriage was real. So they were at serious risk of denial, and they were both very panicked and concerned about what to do next. Of course, I'm glad that they sought my counsel, because I was able to go ahead and tell them if they hired me, I'd be able to help them. So they did, and I went ahead and responded to the notice of intent to deny. Usually when you're applying for this, you have to respond within 30 days. Right now, they have a flexible deadlines just because the COVID, and they have flexible deadlines until October. But usually you have to reply to the notice of intent to deny within 30 days of receiving it. And if you don't, you're going to get a denial after that. So in this case, we went ahead, we submitted a response, and we just got the approval today. So it made a complete 180 degree turn, in that it went from the intention to deny to an approval, and their green card is now in the mail. My client is very happy, and I am so happy to get this on a Friday over right before the holiday weekend, so I can go forward and feeling really happy for my client, knowing that they got their 10-year green card and they can move forward with their lives and build their lives together. So keep in mind that if you get a notice of intent to deny, take a breath and give me a call, and we can walk through your process. We can see if there is any way to respond in order to turn that around for you. You can go to the link in the profile, and it's going to lead you to the website where you have everything you need to get in touch with the firm. So now let's talk about that notice of intent to deny in general. Now, the notice of intent to deny can happen with any type of petition or application. And so if you get it, my advice is don't panic. It doesn't mean that you've been denied, and it means that you can still get an opportunity to turn it around. Actually, the USCIS has sent this to you to give you a heads up that this is what they're thinking about. But please, by all means, provide them any information or evidence or legal basis, because the legal basis has a lot to do with this. That's what I did in this case of the notice of intent to deny. I provided a legal basis, case law, established laws, regulations in the immigration, under immigration law, that states why they should be approved. And fortunately, they did agree and they issued the approval. Now, so that can happen with a notice of intent to deny. If you've received that, then that's where you need to get legal advice to determine what the next step should be, and then respond ASAP. The time is of the essence. because you have 30 days to respond to this notice, or you risk denial. And it has to be a timely response. So if you have this, go ahead, make sure you schedule right away. It is an emergency, and you want to make sure that you have the right footing to move forward and get a response into them ASAP to try to turn your case around. And what that response is going to look like is going to depend on your facts and circumstances, and whether there's anything else that can be done. Now, how long approximately will USCIS take to send someone to biometrics after filing VAWA adjustment of status? So I would say about 2 months to get that adjustment of status. And I see here on YouTube, change of status, then F1 and EB3, green card, is it possible or not? If possible, what to do for getting the green card? That is possible. Now, to go from F1 to EB3, however, whether the change of status is feasible for you in particular is going to come down to your circumstances. So that's where it's important to get legal advice. If you're going from F1 to EB3, it means that an employer is now applying for you. EB3 is an employment-based permanent resident. It means an employer is applying for you. You have to go through labor certification process. And then after the labor certification process is approved, then you go through the adjustment of status process. During this period, you have to be very careful about working without a permit. You should not be doing it. It could be a big mistake. And you also have to make sure that you maintain your legal status. What happens next after petitioner just found out the letter this year from NBC dated 2015 after the USCIS approved the petition, and also in the letter there's no invoice ID. So Zenaida, it's going to depend on what type of petition, what's your priority date, where are they now, have they started processing your petition? You may have gotten an approval, but maybe they're not processing your case yet, and that's why you haven't been issued an invoice ID. So go ahead and schedule a consultation. That's very specific, and it's really going to come down to a lot of follow-up questions in a consultation. All right. Keep those questions coming. These are all great questions. Thanks for the follow. Thanks for the love. I appreciate it. Keep it coming. These are all good questions. And thanks, Nikisha, for the congratulations and the support. All right. Keep those questions coming. I am, in the meantime, while I wait for more of your questions to come in, I'm going to tell you how to get in touch with me. And so, Julio, you just asked me a very relevant question. And yet, how much is the consultation fee? It's $150 for up to an hour. We do a detailed consultation for up to an hour. So I go through your circumstances, through your facts, and it is well worth your time and money because you avoid mistakes, you know your options going forward, and you can understand your process, and you have access to legal representation should you qualify to, so that we could get started right away. Thanks for the follow. Thanks for the love. Now, the way you can schedule the consultation is by going to the link in the profile. You'll see the phone number. You will see the, so if you click on the link, it's going to take you to the website where you can schedule your own appointment. You can go ahead and go to the website where you'll see the phone number, you'll see a contact form, you'll see online chat. So many different ways to get in touch and schedule your own appointment, or call the office to have a scheduling coordinator assist you. The phone lines are 24/7. Scheduling coordinators are on duty from Mondays to Fridays, 8:30 a.m. to 6:30 p.m. However, if you want to call, and on Saturdays, by the way, the scheduling coordinator is available 3 p.m. to 5 p.m. If you are calling outside of the hours of the scheduling coordinator, that's okay too. There are receptionists that still answer the phones 24/7 to pass your information onto the scheduling coordinator, and they get right back in touch with you on the next business day. So plenty of easy ways to get in touch. When filing for, so what to do when spouse gets deployed while waiting for the interview. So if you do have evidence that your spouse is deployed and on official duty, they may allow you to do the interview by yourself, attend the interview on your own. That's an exception to the general rule that they want to see both spouses there. However, you do have to provide that solid evidence that that's the case. When filing for your filing for your children under 21, if you file 2 months before 21, will it be processed as a child? So that's going to come down to what kind of application are you filing for? Are you a US citizen filing for them under 21? If so, their age freezes at the time that you apply for them. If you're a permanent resident, then it's maybe different, but they still may be able to, you may avoid aging out, but it's going to come down to a certain calculation and what type of petition, what type of application it is. So that's where it's important to schedule that consultation. So just got the invoice ID last August after the applicant sent an inquiry. So Zeneda, that's very specific. I need to understand your case in full. I wouldn't be able to answer your questions without reviewing everything in a consultation. Let's keep these questions coming. These are great questions. How long does it take after you send in your documents to prove real marriage to receive an answer? So it's going to depend on the service center and what their caseload is. I would say give it a couple of months. And if this is a response to the RFE, definitely it's going to take a few months. How long does it take for a stepfather to adjust status for a child under 18? So I wouldn't be able to tell you the specific timeline just because cases are different, service centers are different. But what I would say is it could be anywhere from 6 months to 12 months, just depending on what's going on in the case, the complexities of the case, and so forth. Can I file VAWA with 2 dismissed misdemeanor cases? Nothing major. That's where you're going to have to schedule a consultation. Anything that has to do with a charge for an offense, even though it was dismissed, you need to schedule that consultation. The good news is VAWA is very flexible. And so with the dismissed misdemeanors, it's possible to apply, but I would have to understand your case and the facts behind your case to understand, even though it was dismissed, is it still considered a conviction? And will you need a waiver? If you need a waiver, then it's important to file it with the VAWA, but we'd have to understand what's going on first. So schedule that consultation. Can't stress enough. Make sure you're protected. Make sure you do the right thing by getting legal advice. Great. I'm seeing some great questions on YouTube. Hello, my marriage application I-130 with US citizen was received last week, and today I saw they cashed the money order. When can I expect a receipt from the USCIS? Can I get a driver's license with a receipt? So usually you can't get a driver's license. It depends on the state, but usually the receipt notice is not enough. Usually maybe the work permit and your SSN will be required, but in some states, they don't even require you to have that, that information. Sometimes they just require you to prove your residency in the state. So it's going to come down to what your facts are. Hello, our family-based parents' green card petition of February 22 is in process. So far, we have received EAD and Social Security card and I-69 deficient notice. When can we expect our interview or interview waiver? So I wouldn't be able to tell you the timeline. Remember, every case is different, especially when you start to get, if you do, first of all, if they ask for the request for evidence on the medical examination, are they asking for that to make a decision, or are they asking for that in general? Have they indicated that you need to take that to the interview? So, it could be a couple of months before you get an answer. All right, keep those questions coming. Loving the questions. And thanks for the love, by the way. Thanks for the gifts. How long does it take for a stepfather to adjust? So I answered that. Thanks for sharing the live. What can you do if you're filing for your child and other parent doesn't want to sign the papers? So that's complex. Get legal advice. Definitely, it's going to come down to where are the children. If the children are in your country and they don't want you to go, it may be more, they don't want the children to go. It may be a more complex issue, especially if you're dealing with a custodial parent. You may, that's going to maybe even extend beyond immigration law. Is the green card cost over and above all the fee to you? So I don't understand that question. Now, fees, I don't provide fees through the live. I do provide fees once I've evaluated your situation and determined the extent of the extent of the representation. So that's where the consultation is going to be very, very, very important. All right. So I see I petitioned my son when he's still 20 and they approved him over age 21. I thought it's automatic that he's still in the Child Act law. So that is a possibility. If you're a US citizen and you filed for your son when he was under 21, it freezes his age. So that means that he would be able to get, so it's called the Child Status Protection Act. And he would be able to not age out based on that law. But when it comes on to other permanent residents, it's going to depend on a specific calculation or if other types of status. I would come to the US, so let's see. Can you tell me anything about H2B visa holder? So, it's a work program. So certain countries can get the H2B to work in certain areas. So, and Wilson, that's where the the Child Status Protection Act is going to come in. And so it's not automatic, but they did a calculation, a specific calculation to determine whether he was protected under that law. So that's what happened in your case, but it is not automatic for everybody. So that's what you have to note. If your child is about to age out and you're a permanent resident, or even if you're a citizen, get legal advice, because you may think that your child is protected under that law and it may not be. It's all dependent on a specific calculation under immigration law. Hello, how do I find out if someone has filed for the green card? So that it's gonna come down to a lot of questions here. I don't, that's hard to answer just because I don't know if your husband has your husband filed for the green card. Now with my clients, when I get a client, my clients, we do a FOIA, and the FOIA, if, for example, if you're trying to verify whether your spouse filed for your green card, then we would run a FOIA. As FOIA is a Freedom of Information Act request, and that's going to tell us what's pending or what records they have on file for you. Came in 1996, lost my old password with the visa. Passport with the visa. How can I prove of entry to adjust my status? So that may come down to a number of other types of, so for example, looking up the I-94. If you don't have the passport, then that may come down to even requesting a FOIA, submitting a FOIA request at the CBP. So it really depends on, when did you travel? Do you have a travel history on the visa, and so forth? Go ahead, put your questions in the comments. That's what I'm here for. You're welcome. Can I get advice to your office on my son's status? So go ahead and call to schedule a consultation, and that's where we provide legal advice. While we don't get into the nitty gritty, as in we don't work on forms in the consultation. Consultation is for legal advice. If you do qualify for further representation, then we can represent you on that. Is it safe to travel on advanced parole if we receive it before the green card? Now, whether it's advisable for you to travel is going to depend on your circumstances. For example, if I have a client who they have a complex case where they may have a number of issues going on, maybe they have an arrest in their background, or they have other inadmissibilities, I wouldn't advise that client to travel. However, if you have an overstay and now you're going through adjustment of status and you want to take a brief trip out of the US, then in that case, it may be advisable. But whether it's advisable for you is going to come down to me understanding where you are in your case, and making sure that there's nothing that's pending or outstanding in your case, like a request for evidence. All right, great questions. Why does administrative processing take a long time? Yes, it's one of those nightmares, and it's usually where they have found an issue and they're taking that extra time to look into the issue. So it can take a long time and it's very unpredictable at that point. I have a question. When it's your first time in appearing to immigration court, will they arrest you? So usually if you are responding to a notice to appear and you go in, they usually would not arrest you. However, I don't know if you're at a greater risk of being detained. It just depends on what your circumstances are. But usually you go to what's called a master calendar hearing, where they basically just go over the notice to appear, read the charges, and then find out what your defenses are. It usually doesn't involve arresting you at that point. Usually it's arresting you, then you go through the court proceedings. I have a question. Let's see, can a green card holder get a green card right away for a child 1 year old? So no, if the child qualifies as a derivative, meaning they're on your application with you, yes, but certain applications allow it, some don't. So it's going to depend on how you're getting your green card and whether your child can get on that application with you. Otherwise, you may have to file separately. So my son documentarily qualified and don't need nothing more from me over 2 years now. Don't hear nothing more from NVC. What caused that? So it could be that their priority date isn't current. And Rohan, if you are in doubt, that's where it's important to schedule a consultation. If you are completely lost in your process, it's time to get legal representation. Petitioner is a US citizen, I-130, dated in 2011. Got a letter from NVC in 2015, but found the letter only this year, 2022. Will there be a problem not contacting NVC? So I think I answered that question already. All right. Can a family member, let's see. Can a family member sponsor you to come work for them? If so, how long does it take? So that may be a possibility, but it may be subject to more scrutiny, and it may depend on, so your family member, if they own a business and the purpose of that sponsorship is for you to work for them, then there may be a possibility. There are additional requirements that they would have to meet though, and of course the additional scrutiny that would be involved, but it could be a possibility. I want to file for my daughter in Jamaica. Do I need a consultation? Absolutely. All individuals who are going to get legal advice from me to determine whether you qualify, that's where the consultation is going to be very important. When you get your approval letter, I get a letter for my daughter in May. What's the next step? So if you got an approved I-130, then it means that it's going to be moved to the NVC if they're outside of the country. If they're in the country and they're out of status, there are going to be additional hoops to go through, and that's where it's important to schedule that consultation. All right. How long does it normally take for a J1 2-year waiver? So it could take a couple of months for that waiver to come through. And it depends on how you're applying for that waiver. So there are different ways to apply for the waiver. Are you doing a no objection letter and then submitting it? Or are you doing it based on exceptional hardship? Or are you doing it on another basis? So that's also going to count in the timeline. I'm a green card holder. How long does it take to file for my daughter in Jamaica? I would say about 18 to 24 months. All right, now I'm heading on over to Instagram where I'm going to continue the live there. Thanks for all your questions. It doesn't mean that if you haven't gotten to your questions, I see a number of questions. Guess what? Join me on Instagram. I'm the Immigration Attorney on Instagram. On YouTube, I'm going to put my phone number in the comments so that you can call, and then you can also schedule your own appointment at ST Law Office. Now, to go to Instagram to join me there, go to the Hi there, Vibes Cartel. It's nice to see you. Go to the link and it'll take you to Instagram. Join me there. I'm the Immigration Attorney on Instagram. I'm going to be on there in a minute where we can continue to have this conversation. You can start dropping your questions there as soon as possible. Now, results driven, if you don't have Instagram, you can join me on Monday where I will do the live at around 4 p.m. So join me there. If you can't join me on Instagram, look out for me on Monday here on YouTube or on TikTok where I'll be here around 4 p.m. All right, so see you in a minute. If not, see you in a consultation where we can discuss your particular issue. All right, see you in a minute. Bye-bye.